Hope you're not tired too much. I do my best to wake you up if you're sleeping already. So during our coffee break, during our coffee break, I realized that you are all professionals. Professional businesswomen and businessmen. And interesting is that some of you invited in your business environment your kids. I've seen brothers, I've seen sons and mothers, son and father. So you already have somebody from your family involved in your business. The question is, and I like asking this question my clients who deemed to be professionals. Having a business in your hands, did you ensure to pass it properly to your son, to your daughter, to your kids? Could you please raise your hands who already done these arrangements? Huh? Exactly, this is the result. So we can be very successful businessmen, business owners, but we forget about very important thing, how the things will go when I'm gone. And this is very, very interesting, especially if your business is successful and there's something to inherit. So I would like to show you and to share with you some ideas how properly to pass your business to your family or somebody outside the family if you want to do so. We know that foundations and trusts are very good vehicles for succession planning. However, today will not be talking about trust foundations because Aina was talking about it and Dr. Fanny was talking about it. I just want you to show some typical mistakes which our clients do when they have established a successful business and they think that they've done everything. Typical mistakes. They disregard succession law applicable in the country of company registration. And we have a number of cases when the clients have established BVI company, and then if the single owner dies, they will spend about 1 year in BVI courts to get the shares of the BVI company inherited from his father. 20 months is one case we had. Other case was the shortest case we had about 9 months. In Seychelles, something different. Registration of holding companies with a very standard memorandum articles without even thinking how to pass the shares. And the company is holding real estate, holding yachts, holding shares in Hong Kong company, multi-million profit company. And they forget that holding is something very important. It's holding assets, valuable assets. So you have to think about to whom to pass these assets. Undated share transfer documents. Very often we say, oh, Tatiana, I will undate my share transfer. When I'm dead, somebody will fill it in with whoever name and the date. And I'm sorry to say it will be not valid document after you are dead. Unlimited term powers of attorney also doesn't work. Appointment of nominee shareholder with letter of wishes. Very often we see the cases, Tatiana, we will appoint you nominee shareholder and I'm safe. And this is my letter of wishes, how everything has to go after I'm dead. But do you realize that the nominee shareholder is also the human being? So there are some things which do not work. And those are undated share transfers, power of attorneys, which are irrevocable with unlimited term. So once you are dead, the power of attorney has no validity. Nominee shareholder with ultimate beneficial owner instructions, it also doesn't doesn't work in practice, believe me. As I said, the perfect solution is trusts and foundations, and we can provide you with private foundations in Seychelles, but it's perfect solution, and we live in not in perfect world. Some of our clients, they simply do not understand what the trust means. Doesn't matter how many times we educate them about the trust, how many times we tell them the stories about successful foundations planning. They don't like it. They don't understand. They don't want to understand. They say, I have shares, that's it, finished. Do something to ensure my share is passed to my son when I'm dead. Oh, my share is passed to my mistress when I'm dead. Hoo-hoo. So, we in Seychelles, we have very nice laws which will allow us to structure for that particular client, that stubborn client who doesn't like private foundations and trust, excellent way of passing his wealth to whoever he wants to pass, not necessarily family members. So today we will be talking about companies limited by shares, how we're going to use them for succession planning. Secondly, we will talk briefly about hybrid companies, which are Seychelles companies limited by guarantee with share capital, also very interesting solution. And Seychelles limited partnerships. If you don't know, we have such a legislation, limited partnerships, and it is an excellent tool for structuring succession planning. Before I go to the IBC structuring succession planning with IBCs, what is important to understand that our IBC law doesn't say that the status of the Seychelles IBC shares is in Seychelles, unlike in BVI, for example. BVI law says clearly, status of shares of the BVI company is BVI. It means automatically that the BVI succession law applied to these shares. And this is where you have to spend months in the BVI courts in order to take over the shares as an inheritance, a result of inheritance. In Seychelles, the laws allow to recognize the status of shares of the Seychelles IBC in the country of domicile of the shareholder. It means that if you domicile on the time of death in Czech Republic, or in Cyprus, or in Hong Kong, or somewhere else, it will be the laws of this country which will decide how the assets will be distributed, the shares will be transferred in the IBC. So, I already explained the same in this slide. So, let's have a very simple example, and we're using this structuring for many of our clients who doesn't want to set up private foundation or trust. What we do is set up an IBC with different classes of shares, Class A and Class B. Class A shares has all the rights. They can vote, they can receive dividends, they can do everything like usual shareholding. Okay? However, we also introduce Class B shares, which has no voting rights, no rights to dividends, no right for distribution on liquidation of the company. The only right they have is to attend the meeting. So, what we do for our clients, for the business owner, we issue Class A shares. And for heirs, which he wants to inherit these shares, not necessarily family members, again, Class B shares. And on trigger event, we structure the memorandum and article the way that there is automatic conversion of one class into another. So when the guy is dead, his shares, Class A, automatically converted in Class B shares with nothing. And it is Class B shares which go to his estate to be distributed in accordance with the law of domicile. However, those whom we issued Class B shares become a Class A share owners on the trigger event. And the trigger event can be death, or incapacity of the person, or disappearance of the persons. It all depends on the client, what he wants to see in the memorandum and articles. Okay, so the shares automatically converted, so the company, after the death of the owner, it doesn't stop to run. They are shareholders, they can do decision making, they can receive dividends, and they can vote on whatever resolutions they want to want. So the company continued to exist. We had quite a number of cases. You know that IBC, Seychelles IBC, can be run by one person who is a shareholder and director, one person. Just imagine if that person disappears or that person dies, what happens? Who's running the company? What to do with the bank account? And this is where the problems begin. So we always advise a client, yes, we understand your entity is one-man band entity, but do please ensure that you have somebody on the back of this entity, like shareholders of Class B, who will become, on the trigger event, as shareholders of Class A with all the voting rights and the rights to dividends. Okay. So this is just one example with the limited companies I gave to you. We have other interesting solutions for the clients, also for which we use with our IBCs. If the client doesn't want this Class A, Class B shares, we come with a solution. Okay, let's do the option agreement. You are the guy, but you have all the shares in the company, you are the director of the company, but please do execute an option agreement whereby on the trigger event, somebody with whom you executed the option agreement, presumably your heirs, will become a shareholder. He will have an option to become a shareholder. With the allotment of shares, the company will do allotment of shares to such a shareholder when the guy dies. So the option agreement between the company and anticipated heirs, anticipated means those people which I want to inherit, not necessarily family members. We had cases when our clients wanted absolutely different people to inherit their shares. Then anticipated heirs will have the right to subscribe to shares on the trigger event. During shareholder lifetime, he owns, say for example, one share, giving him exclusive voting and dividend rights. And the one share, when the guy dies, the one share goes to his estate. That's okay. But at the same time, when he dies, the heirs, anticipated heirs, are issued with shares, and they will be in the full control over the company. Okay. Disadvantages in this structure, in the option agreement, is okay. We can sign whatever option agreement with our anticipated heirs, but they can be not ready to run the business. They're not grown up enough to run the business. They don't understand in this business anything. So this is one issue. Another issue, heirs are unwilling to take over. For example, I have two sons. One is willing, another one is not. That's very, very common in our life. And management risk, of course. Even if the heirs want to inherit the business, they don't understand in this business. They do stupid mistakes in resolutions and running the business daily decisions. We also advise in such cases buyback arrangements. We're structuring buyback arrangements for our clients, whereby the shareholder, say for example, he has all shares in the company, say for example 98%, not all, but 98, and he gave 1 share already to each of his heirs, anticipated heirs. This is just example of structure. And with the time, he redeems the shares back to the company, and the company issuing additional shares to heirs when the heirs are ready to take over the company. So, but it's done not on the trigger event, but steadily through the time. Many businesses are structured not like one-man band business, but with a partner. This is also a very sensitive situation when one of the partner dies. What's become with the business? How to inherit this 50% of my father, for example, in the partnership with somebody else who is not a family member. So, yeah, let's, for example, I die. I have 2 sons. Yes, I have 2 sons, by the way. But what will happen if they are not ready? They have no experience in my business, not at all. They make different decisions from what I would do. They are, not very well educated in my sphere. So, and there is a 50-50. 50-50 means there's no majority. No majority means they have to make meetings and make decisions all together with a strange guy who has 50%. And they are not able to do the right decision. So the business will collapse. And it will collapse sooner than you imagine. Some businesses can collapse within 1 month if we have such situation. Another scenario is when the guy dies, or the partner will do the parallel business. He's not interested in my kids to do decisions with them. He will do a parallel business, absolutely the same. He will take over all the customers, all contracts, and he will be the one to succeed whatever I wanted to leave to my kids, and they will be in such sad situation. So in any joint business, if the client has a joint business venture, so they have to agree ahead what to do if one of us, dies. We have to be really serious about it and make preliminary arrangements before such things happen. What could be the decision? Double option and life insurance. But double option, this is a slide to look at. It's we prepare a double option agreement with a call option and a put option. Upon the death of one of the partners, the rest of partners shall have the right to purchase. So the alive guy say, I want to purchase. And if in the option agreement you have this call option arrangements, so if the guy, alive guy, want to purchase, the kids has to sell. And also there is a put option agreement. Upon the death of one of the partner, the representative of the deceased shall have the right to sell. So whoever represents my kids, he say, I want to sell. I just need cash from this business for these kids. And another partner has an obligation to buy. So this is a kind of arrangements which can be done preliminary before anybody dies of all these partners. So this is how it looks like. Okay, doesn't matter. You will have all the slides. We move to another vehicle which is available in Seychelles. So far we've been talking about the IBCs, simple IBCs. We know that it's a limited company, limited by shares. Now, in Seychelles we have also hybrid companies. A company is limited by guarantee with the share capital. This is where we have at least one shareholder with shares in the capital, and we have guarantee members. we have a director of the company to run this hybrid company. This is how the hybrid company looks like. The shareholder, he owns the shares with the right to vote, to receive dividends and receive surplus on the dissolution of the company. The guarantee members, they don't have the right to dividends. They don't have any shares. They are just members. It's just like a club. But the guarantee member has an obligation to pay like $1 or $100 on the liquidation of the company. This is all the guarantee member must to do, nothing else. He's not running the business, guarantee member. He's not in charge of the company. He's just subscribed for the obligation to give the company $100 on the liquidation. Members can be appointed by a director. Neither guarantee member nor the member are indicated in the register with Dr. Fanny. Income is distributed at director's discretion. Whatever director resolves to distribute income from the hybrid company to members and guarantee members, it will be exactly how in accordance with the resolution of director. If we compare this structure, the hybrid company, to the private foundation, hybrid companies are more simple. They are companies. The clients, they do understand it's company. It's not a private foundation. The hybrid companies may be engaged in the commercial activity, unlike private foundations. Private foundations, they are for asset holding only. But with a company, you can do the business, for example, trading or any other businesses. So how we solve succession in such case? We appoint a quasi-trustee who has one share, because the company has to have at least one shareholder. We give him a minimum share, just one, not 100%. He's not the guy who owns the business. He's just doing something, trustee. So, and we have a guy, a real guy, the business owner. He is a guarantee member. And during his lifetime, he received 100% of income from hybrid company. All dividends go to him. We have an agreement with a quasi-trustee that he doesn't receive any dividends. He receives a fixed amount of money, let's say for once in a year or once every month, whatever. And those guys, members of this club, can be your heirs. Anticipated heirs, not necessarily family members. So they receive nothing until the event happens. Which event? The event when the guy with 100% dies. So when the guy dies, one second. When the guy dies, his estate goes, his membership doesn't form the part of the estate. The members, his kids or whatever, they become the guarantee members. We can draft the memorandum and articles the way that the members become the guarantee members. Okay, I'm sorry, I have limited time. So, yeah, this is exactly what I've been talking about. The guarantee member goes, and we have another guarantee member who becomes the heir. Who was anticipated here, and he became a guarantee member with 100% right to receive income from the hybrid company. But the guy there, shareholder with one share, remain untouchable. Another solution is limited partnership, but I understand we don't have much time with it. If you're interested in succession planning with Seychelles Limited Partnership, I will be glad to answer all your questions during the break. And I'm sure now you have a better idea than in Seychelles we can accommodate people who would like really to structure their succession for anticipated heirs. Thank you.
Thank you, Tatiana.